Psychologically, if you can motivate a reader to be emotionally invested in your client's case, then you're much more likely to convince the reader to overcome maybe some inherent bias that the person has about the law in deciding the case, and you can continue to motivate the reader to read through the rest of your brief if they're interested in the facts of your case. To write a good statement of the facts and to use the facts well in your brief, you should be looking for visually concrete language so that the reader can really see the story unfold and understand visually how your facts played out. First and foremost is in your argument to make sure that you provide enough context before detail. And we talked about using headings and roadmap paragraphs. A good heading should be about a sentence long. It should contain the argument that you're driving and include a key fact from your case. We also talked about using roadmap paragraphs, and a roadmap paragraph is a summary under each heading, typically a paragraph long, where you summarize your legal argument and how the argument applies to the facts of your case. That summary really captures the reader's interest about your case and also helps the reader to understand how the law applies to the facts of your case. So it's a very important part of the brief. Finally, we talked about positions of emphasis. And a position of emphasis is really where the reader is paying attention. Again, psychological studies have shown that that's at the beginning and at the end. So the positions of emphasis in your brief are the beginning and end of your brief, the beginning and end of a paragraph, or the beginning and end of a sentence. So you should be putting what's favorable for your client in those positions. So the law that's favorable, how the law applies to the facts of your case at the beginning and end of the brief, the paragraph, or the sentence. You can put counter arguments or a discussion of how bad facts in your case work into your argument into the middle of a paragraph, the middle of the brief, the middle of a sentence to help diffuse the bad law or bad facts, which you are ethically obligated to talk about, but you can minimize their importance by putting them in the middle. Avoid block quoting because people just don't read block quotes. So to the extent that you're going to be quoting, you should try and introduce your quote and you should explain what the significance is of your quote, and you should try and keep your quotes short. So that you can work them seamlessly into what you're already saying. Finally, a more small-scale matter, but really important, is to make sure that the formatting complies with the rules that the court requires on formatting, and also to make sure that your document looks visually appealing. So that helps to create credibility, it helps to create readability for the court to want to continue to read your brief.